नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Ratification result into what? Ratification established the relationship of principal and agent, right? After that act is concerned. तो मतलब आपके if I was the person on whose behalf you acted without the knowledge, without the consent, but later on if I will ratify, then insofar as the act ratified is concerned, person ratifying will be the principal and whose act will be ratified will be the agent. And let me tell you, the ratification established the relationship of a contract between the third party principal मतलब लेने में और third person के बीच में it will be a binding contract. So let me just tell you, you acted on my behalf without my consent. You made a contract with third party, and later on, if I'm going to ratify that, what will be the impact? आपके और मेरे बीच में, how far that act is concerned, there will be a relationship of agency, and another impact is what? Me and the third person with whom you made a contract on my behalf, we will be bound with the contract made by you as according to the agency law. Right now. Always remember, last thing I want to point out about the ratification. On ratification, there will be always application of doctrine of relation back. Doctrine of relation back. And I hope doctrine of relation back means it will be bound from the back date on which you acted without my authority, without my knowledge or consent. Is ratification clear to everyone? There can be a specific question on ratification only. Is it clear? Please answer. Okay. Then let us talk about now determination of agency or termination of agency. Okay. As per you please try for it. As per you, suppose you went into exam, you went for exam without study. Now try to use your creativity, right? Your general knowledge or otherwise your IQ level. Try everything. That what do you think that what are the ways of revocation of an agency? How we can determine agency? How we can terminate any agency? Ways of termination. Anyone?
So, ma'am, the first would be when the task or act for which the agency was entered into is completed. So that would lead
to completed
termination.
Okay, first of all, let us talk about whether agency can be terminated or not. पहले एक जनरल क्वेश्चन करते हैं खुद से, whether an agency can be terminated or not, or whether an agency will always be an agency. Whether you can terminate the agency or not? Answer is yes.
Yes, ma'am.
Always, right? And what are the ways? We will start from the basic. We will read your first of all section 201, and out of your section 201, we will take out the modes of the termination of an agency. Now read your section 201. There can be a separate question on your termination of agency. Let me tell you, for your LLB exam, there will be a short note on agency. It can be directly on like ratification of agency. It can be directly on termination of agency. So these are very suitable for the short note. So please pay attention to it. So termination of agency. An agency is terminated by principal revoking his authority. Right? The agent can revoke his authority, and this is the first way. By revocation. Second, by agent renouncing the business of agency. So ये कुछ difference नहीं है. हम कब word use करेंगे revocation, कब word use करेंगे renunciation. Revocation when it will be terminated by the principal. Mark my words. Revocation will be used as for what situation where the agency will be terminated, revoked by the principal. And renunciation or renouncing word will be used where the agency is terminated or revoked by whom? By the agent, right? Or third way, or by the business of agency being completed, as it is rightly pointed out by the Tanvi. So you keep writing itself on your bare. First is principal revoking the authority. Second, by agent renouncing the business. Third, by the business of agency being completed. Fourth, by either the principal or agent dying or becoming of unsound mind. So this is something new, that if somewhere either the principal or agent, any one of them died or either any one of them turned to be unsound mind, then automatically there will be termination of agency. This is the fourth way. Right? Then read further, by principal being educated as an insolvent person. So if it is very much clear, it is the basic principle of your Indian Contract Act. The moment someone will be disqualified by any other law, right, then he will not be entitled to contract. And moreover, I believe everybody knows that if someone turns to be insolvent, there cannot be enforcement of contract against him. So fourth way is where the principal being adjudicated as what? As insolvent, right? And next, which is here, for the time being enforced, for which relief of next, which I want to add on the expiry of the time, right? Suppose you and me entered into contract of agency and it was for 5 years. The moment the 5 years will expire, the automatically agency will be revoked. So let us just conclude. By revocation will always be by principal. By renunciation will always be by agent. By completion of the business, for what purpose the agency was formed. Fourth, by the principal or agent's death. Or fifth, by the principal or agent becoming unsound mind. Sixth, insolvency of the principal. Seventh, expiry of the time. Now we will take up one by one and we will wind up this topic and this concept as well. So first is by revocation. For revocation, please see your section 203. 203 in your Bear Act. When principal may revoke agent's authority, the principal may, save as is otherwise provided by the last preceding section, revoke the authority given to his agent. Now please mark, at any time. Please इस phrase को mark करो. At any time before the authority has been exercised as to bind the principal. So section 203 is just making you clear that a principal can revoke the agency anytime. Please mark it anytime. But there is a one condition, anytime before the before the power exercised by the agent. Agent ने जब तक कोई contract अभी आपके behalf पे complete नहीं किया, till then you are free to revoke your agency. It is just similar to your offer and acceptance. Up to what period you can revoke your offer? Till it is not accepted. In case of your offer and acceptance, you must have done that matchstick and gunpowder example. आप कब तक offer, up to what period you can revoke your offer? Till there is no matchstick to the gunpowder, till there is no lightning of the matchstick to the gunpowder. So आप gunpowder हटा लोगे, there will be no explosion. Similarly, till the agent has not exercised the power, you are free to revoke it. But once he has exercised, you will be bound with the contract made by him towards the third person, right? So section 203 is always to be read with your section 207. Section 207. And section 207 is talking about what? The revocation and renunciation may be expressed or implied, right? Revocation or renunciation may be expressed or implied. So this is equally applicable to the termination of agency by the principal or by the agent, because two terms are used here, renunciation or revocation. So it is applicable to both. So revocation can be implied or expressed. I'm giving an example. I have taken from your Bear Act only. Suppose I appointed you my agent for selling my house. Yet you were in process, you did not had a word with someone, or अभी आपने finalize नहीं किया contract किसी third party के साथ. Before that, I sold the house myself. So it is what? It is implied way of termination of agency, because object is completed. I did it myself. It is implied revocation of what? Of the agency. So this is one thing. Now let us talk about that section 204. I want to add on one more thing. Whenever we are talking about revocation, please listen carefully and mark my words. Whenever we are talking about revocation can only be prospectively. Means revocation cannot be done retrospectively. आप किसी चीज को ratify तो कर सकते हो retrospectively because ratification will always be from the backdate relation back theory. But the moment you are going to revoke any authority which was earlier in existence, it will be always prospectively, right? Prospectively. So, if I gave you a right, I gave you an authority, power to act on my behalf on 22nd September, and you exercise that power on 23rd, and you make a contract with someone on my behalf. और उसके बाद मैं आपको I'm going to revoke I'm going to revocate the agency between you and me, so that will be effective from the 25th onwards, right? For the 25th on for your any act which is after 25th September onwards, and for your act which you did on 22nd September or 23rd September, which you have already done, that cannot be revoked because section 204 of your Indian Contract Act is making it clear revocation operates prospectively only. Now read your section 204. Revocation where authority has been partially exercised means you have done already something. So principal cannot revoke the authority given to his agent after the authority has been partially exercised so far as regard such acts and obligations as arise from the acts already done in agency. Please mark this word, from the acts done already in agency, right? Another thing which is here required for the revocation as well as for renunciation. So just like your earlier section 207, the next section which I want to make reference that will be applicable to the both cases, section 206. So that is what notice of revocation of renunciation. It's quite simple from its heading itself. If somewhere the principal is going to revoke his authority, somewhere the agent is going to renounce his authority or the agency, then they are bound to give the reasonable notice of it. If it is a case of revocation, then principal is bound to give the notice to agent. If it is a case of renunciation, then agent is bound to give the notice to the principal. So reasonable. Again, focus on the term reasonable. We cannot give any particular hard and fast straight jacket time period for that, right? So it is to be determined by the court from case to case. It will vary from case to case depending on the facts of the case. So reasonable notice must be given to such revocation or renunciation. Otherwise, if you have not given, then the term please mark which is here. Otherwise, it is giving your proviso. Otherwise, the damage thereby resulting to the principal or agent, as the case may be, must be made good to the another. So suppose as a principal, I am going to revoke the agency without reasonable notice, then I will be bound. If they later on, if there is any damage to third person, if there is any damage to the agent, then I am bound to make that damages good to the another person. Means I am bound to make the damages good to the agent. So this is what all about what the revocation. Now let us talk about the concept of compensation. If somewhere there is revocation or renunciation by the principal or agent respectively, then there is a concept of the compensation for those damages. So for that, read your section 205. Section 205. Compensation of revocation by principal or renunciation by agent. So read the provision. Where there is express or implied contract. So it is applicable to both. Where there is an express or implied contract that the agency should be continued for a particular period. Means that we entered into contract of agency, whether that contract of agency is express or contract of agency or implied contract of agency, right? Then it and we agreed there that it will continue for 5 years. Right? Then if anyone is going to break, anyone is going to renounce the agency or revoke the agency before that period, then such person will be bound to compensate to another. मतलब 5 साल से पहले as a principal I'm going to revoke it. Definitely as an agent you are going to suffer because of that earlier revocation. Your commission, everything is going to be affected. Then as a principal I'm bound to give you compensation for that. And as an agent, if you are going to renounce the agency before the completion of 5 years, then definitely it is going to affect the interest of the principal. So as an agent you will be bound to compensate for that. Now read further. Agency should be continued for any period of time. The principal must make compensation to the agent or agent to principal as the case may be for any previous revocation or renunciation of agency without sufficient cause. Please focus on this term, without sufficient cause. If the revocation or renunciation is for sufficient cause, then there will be no compensation. Compensation will be only in such cases where it is without any reason, right? And moreover, what is sufficient cause? Again, it is a question which is of a question of fact to be determined by the court and will vary from case to case. Thereafter, as we have already done, whether it is renunciation, whether it is revocation, reasonable notice is required in every case. Now let us talk about a different situation which may be there, that in contract of agency. Okay, just understand one thing. Suppose there is a contract of agency between you and me as a principal and agent. ठीक है, you are acting as my agent, but it may be possible that you do have any interest also in that. Okay, let me just clarify you. Suppose there is one principal, one agent, one third person, or contract of agency has been formed to make a contract between the principal and agent, principal and the third party. अब ये भी तो हो सकता है ना, somewhere the agent who is however bound according to the contract of agency may also get some interest in the subject matter, means the subject matter of the which is a subject matter of the agency, which is a subject matter of the principal and third person contract, right? That can be of any interest to the agent. और उस केस में अगर principal is going to revoke it, then what will be the situation and law for that? So please see your section 202 dealing with that specific situation. Section 202. Read it. So termination of agency where agent has an interest in the subject matter, where the agent has himself an interest in the property which forms the subject matter of agency. The agency cannot, in absence of express contract, be terminated to prejudice of such interest. So if somewhere the principal is also interested in the subject matter of agency, then the agency cannot be revoked by the principal unless and until there is an express provision for revocation in the contract of agency between the principal and the agent. And for that, please read your illustration A to your section 202. A gives authority to B to sell A's land and to pay himself out of the proceed the debts due to him A. A cannot revoke. Suppose itself in the subject matter, the agent is also here to satisfy his debt, his interest is also involved. Then it cannot be solely revoked by the principal unless and until there is any express provision for that or express condition agreed by the principal and agent. So this is what where the agent is also having interest. One thing while dealing with such situation, you always need to take care that the interest of agent must be existing at the time of the formation of agency. ये नहीं कि later on while dealing with the subject matter of the agency, while the agent was dealing it with the third person on behalf of the principal, then he got developed his interest. No, it is required that interest must be existing at the time of creation of agency. Please listen carefully. It is required that interest must be existing at the time of the creation of agency. So after this, let us talk about another mode of the termination of agency. That is your completion of business, as it has been given in your section 201. If somewhere the purpose, the object, the business for which the agency was created, that is completed, or if there is any another situation as explained by your section 201, if there is death or insanity of the principal or agent, either of them, then it will be what? It will be terminated. And another, as we discussed earlier, if there is insolvency of the agent, everybody knows that the moment somebody will be declared, somebody will be adjudicated as an insolvent, then according to Insolvency Act, there will be no action against such person. So automatically, if he is having any contract of agency, that will be terminated. Another thing is what? On expiry of the agreed period, it will be terminated. So now let us talk about the effect of the termination. We talk about that how termination can be done. Let us talk about now that what is the effect of termination. For that, please mark your section 208. Read your section 208. What is the effect of termination? So read it. When termination of agent's authority takes effect as to the agent and the third person. The termination of authority of agent does not, so far as regard the agent, takes effect before it comes to known to him. Read it. The termination of authority of agent does not, so far as regard the agent, takes effect before it comes to him, or so far as regard to the third person, before it becomes known to them. So, agent के लिए termination of agency, please listen carefully. It is just similar to your acceptance of the contract offer. It is little bit technical, so listen carefully. Suppose as a principal, I am going to terminate any agency, but when it will be effective against the agent, then it will come into the knowledge of the agent. मैंने खुद सोच लिया, मैंने थर्ड पार्टी को बोल दिया that I am going. Third party means not relating to that contract of agency. Third party means I am having you as my agent, and I informed your friend. Unless and until I will not bring it into your knowledge, unless and until it is not communicated by me to you, the contract of agency will not be revoked. And similarly, with whom the agent was dealing, the third person with whom the agent was dealing on my behalf, right? That person will also be bound with that revocation only after having the knowledge of such revocation. And things can be clear to you the moment you will read the provision, illustration to your section 208. Thereafter, let me talk about that we studied one concept, sub-agent, right? And let me tell you, the moment the agency will be terminated, automatically the sub-agency will also be terminated, right? It is created by agent. The moment the original agency will be terminated, the sub-agency will also be terminated. And this has been, given under your Section 210 of Indian Contract Act, which is talking about what? Read the provision from your whereas the termination of the authority. The termination of the authority of an agent cause the termination, right, of agent's authority to all sub-agents appointed by him. To all sub-agents appointed by him. Is it clear? So, with this, we have completed your entire concept. I have tried to cover each and every section. I would say I have covered each and every section of agency because of its relevance to your career. I did not skip anything, but at the same time, I just want to tell you that you need to prepare this concept only for the bare interpretation, and there will be short note, right? From your next class, we are going to start the partnership, Indian Partnership Act.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।